Welcome to Looking at Legal Stuff. Today we have 5 hearings in a case with a man who is supposedly suing a woman he claims is his ex over some sort of property he says she owes him. He claims he's already spent $40,000 on lawyers this year and can't afford one anymore, so he's just trying to do his best. The ex and her lawyer claim that that's not true and that they were never in that kind of domestic partnership. But even if they had been, it doesn't matter because he's delayed his own case for so long now by missing hearings, refusing to participate in discovery, and not setting the case for trial that according to local court rules, the case must be dismissed. He claims he didn't know he only had a year to set it for trial, so it's really not his fault. Let's see what the judge thinks about this.
And on the 23-3-103-8, Roberts and Rauch, Ms. Baldwin, this was your motion. I see Mr. Roberts is present.
Oh,
Yes, I am.
so some things have changed and some things have not since filing this motion. So the motion is to get Mr. Roberts to participate in a CR26I. He did participate in a CR26I. We're still in a position where he has not addressed the CR41 issue. Case has been pending for almost a year now. And with Mr. Roberts sort of, again, kind of coming in and out of his own case. And so at this point, what I'd ask the court to do is he did participate in the 26I. I'd ask the court to set it out to March 12th. We'll see sort of where he goes from there, if he addresses the other issues that need to be addressed or not, and then we can review it and I can provide the court an update on the 12th.
Excuse me. So you're just simply asking to continue this hearing to the 12th?
I think that's a reasonable way of addressing it.
Mr. Roberts, it sounds like you're at least addressing some of the issues. Any objection to just setting this hearing out to the 12th, and you can work with Ms. Baldwin and see if we can get this resolved?
No, that's what me and Miss Baldwin talked about the other day. So
okay. So if you
I
can...
was in court. I was in court last time we had our meeting, but I didn't know it was on Zoom. I was sitting in the courtroom and
got it. Okay. Well, you're here now. We've got that on the record, so you're definitely here today. So I'll set this on for and you can appear either in person or Zoom on the 12th. We have both available. So the 12th at 1 o'clock, and we'll review it. And if everything is resolved, feel free to strike the hearing counsel.
All right, very good. Thank you, Your Honor. That's it for this matter.
I won't be entering an order today.
No, you won't.
Ms. Baldwin, the Roberts and Rauch matter, 23-3-103-08. I think I see Mr. Roberts is present.
yes, I am.
Yeah.
Afternoon.
So we were reviewing discovery status. I saw a declaration that said nothing had been received.
So here's where we are. For the record, I'm Chelsea Baldwin. I represent the respondent in this matter. The original motion that we filed was essentially regarding CR26I as well as CR41B. And that's because we have a long history, essentially a year to date, of really non-participation by the petitioner. And so we have, he files this case, we have a mandatory settlement conference, he doesn't appear. I try to get a CR26I with him. It takes a motion to make that happen. We do this, finally get the CR26I. He then doesn't provide materials timely. I will tell the court that he did provide me some materials, but not on the date that we discussed, and certainly not all of them. Kind of I'll provide what I want to, how I want to, is my impression of what I was very recently provided just a few days ago. And so where we are now is really at the place where I'm addressing the CR41 issue with the court. So we have CR41. CR41 is very clear. The case has been pending at this point for over a year. And this isn't a case where there's been active litigation. We have someone who has a history of non-participation in his own case that he filed. This is not a case of a marriage. This is a case where somebody's making a claim of a committed intimate relationship where my client denies that being the case at all and says essentially this is a case of harassment from somebody that was amounted to a relationship, but certainly not a committed intimate relationship, and that this is sort of a land grab after the fact. So at this point, my client is asking the court to follow CR 41. Case has not been noted for trial. He's not attempted to note it for trial. We've set it out. He did not use any of that time. It's been set out quite a bit from the original filing of the motion. I think we filed the original motion was back in January. So it's been pending for quite some time. So at this point, it's been months, still hasn't had it noted before the court, and we're asking the court for dismissal.
Mr. Roberts,
Yes, Your Honor.
any response to that?
Yes, I have answered her questions of discovery, and I have turned them into and filled them the best I can because all my paper documents and stuff that she was asking for were with our home that I couldn't get to. I was there in court the day that she said I didn't show up. I was at the courthouse. And I was sitting in courtroom 3 and I realized it was supposed to be on Zoom. And by the time the court clerk office got me into the booth, it was too late. I've been trying my best. I'm doing this on my own. I answered the questions she asked the best I could. I put questions, I gave questions to her. I have not received any answers back to. Just wish to continue this. I want to reschedule a settlement conference. I've done everything I've been told to do from the courts on this matter to fill out. I'm doing the best I can and I'm doing as fast as I can.
So I guess I'm a little confused you're talking about the settlement conference that was?
Yes.
Zoom?
I was at the courthouse, but I never got a chance to get in to talk to her. They said it was too late. So I would like to reschedule a settlement conference if I could. It really wasn't my fault why I wasn't in there. It didn't say I was on Zoom, and when I tried to get on Zoom, it wouldn't let me in. And the reason that a lot of the problem of this is I moved from my previous address to the new one, and it took 13 times we've done where you redo your mailing, change address. 13 times it took before we started getting our mail. And we're still not getting it all. So I don't know what I can do. I ran out of money for attorneys because of previous things regarding me and her. I've already spent $40,000 on attorney's fees this year.
Oh.
I've already, I took out all my 401k. And I'm just trying to do this on my own.
When you're ready, Your Honor.
And I have given you all the information you asked for that you had. So I don't know what questions you say that I didn't give you. You gave me like 45 questions. I answered them all the best I could. But now I have put in for questions for Ms. Roush and you, and I have not received anything back on this discovery questions.
Wait just a second here. So looking
Yeah,
at,
there's what I've gotten from Ms. Roush is their financials and stuff are nothing. There's absolutely nothing there.
I'm just looking at the record in the case here. So you filed your motion on the,
January 19th, this motion,
January 9th,
19th.
19th. Okay, that's nice. Okay.
Man, I'm more than willing to move forward on this case. I'm just trying my best, Your Honor. I'm just,
So it looks like, I'm not sure that this under 41A, I mean, there was definitely a motion hearing in June of 2023.
I'm at 41B.
I'm sorry,
41B, it would be involuntary dismissal.
I'm looking.
So 41B1,
41D1.
no, B is in boy. So involuntary dismissal. So any civil action shall be dismissed for want of prosecution whenever the plaintiff, counterclaim, cross-claim, third-party defendant neglects to note the action for trial or hearing within 1 year after any issue, essentially once the case is complete, unless the failure is the result of my client, which is not the case here. I have to give at least 10 days notice to him. Notice has certainly been provided at least within 10 days. And then if he had noted it up for trial in any point between January and now, then that would have invalidated the motion, but it did not.
Check something here. So with respect to that specific claim, sir, did you have any response you wanted to make?
yes, because the mail is not my fault. I mean, I thought I can't remember if I turned in a statement from the mail people stating that I've had problems with my mail, serious problem. I did not get any of her paperwork until like 3 weeks ago, 4 weeks ago, something like that. So I just want to move forward on this. I'm doing everything I'm supposed to be doing now. I was at the courtroom. I did not, I wasn't there. I tried to be there.
That's a different issue, sir. This is an issue
Okay.
of failure to set it for trial within the time.
A year.
Mm-hmm.
I didn't know about that, Your Honor.
And you said you received this motion 3 weeks ago, is that right?
I guess my wife will. Yeah, approximately 3 weeks ago.
Okay.
When she sent our discovery, Miss Rouse just. Yeah, and she told me I had 2 weeks. She'd give me 2 weeks to turn in the discovery, and I turned in as fast as I could. I wasn't.
All right, I understand. That's a separate issue from what we're looking at today. Okay, so looking at your motion from January, the one I'm talking to Ms. Baldwin for a second here, sir.
Oh.
This talks about CR 41 for failure to comply with discovery in court orders, but that's not
Right, so then
B1.
further down, not appear or otherwise respond to this motion, relief pursuant to CR 41 and CR 26 for noncompliance and failure to prosecute his claim.
I'm just looking at 41B1 though. That's a trial setting issue, which is not what the request is under. So we go back to 26.
Right, but the 41 is failure to prosecute a claim, and that is what 41B1 is. So it's failure to set for trial, but it's for want of prosecution. I mean, the beginning of 41B1 says for want of prosecution.
But that's not the basis of your motion, is what I'm saying.
I guess I see failure to set for trial as want of prosecution. I mean, failure to move your case forward to trial. I pulled the language.
I see. I was reading the wrong spot of the motion. My mistake. I was reading that part. All right. I think based on that reading of the rule, this case has been pending for since
March 7th.
March 7th of 23. And there really has not been a lot. And there was I think given those circumstances, notice this motion was, sounds like it was received at least 3 weeks ago. And there's been a number of things filed, none of which are trial notices, but there are other kinds of hearings which don't appear to be.
I did have the conference with her though last time. On the phone with,
I understand that, sir, and that's not the basis of anything I'm looking at here today.
okay, I'm sorry,
Okay.
Your Honor.
No, you're fine. I'm just looking at the motions that were filed. There's an order to show cause for vacate of a judgment. There are a couple of other motions. Let me see, but I don't have a trial setting. So I'll grant your motion under 41.
It has to be sent over 2 weeks for a presentation. Well, let's make it 3. I want to make sure it gets to him.
Over to the second.
Yes. Let's make it 4 weeks then. I think I'm not here on the 2nd.
Over to the 9th of
9th.
April. So basically, sir, what that means is she's going to prepare an order, send a copy to you.
Okay.
Essentially, the case is going to be dismissed for failure to prosecute the case within the timelines.
How, Your Honor, can I ask you a question? I can't answer I answered it in the best time I had when I
No,
first got.
this has to do with not setting the trial for a year after setting.
I didn't know when to set a trial, Your Honor.
All right.
I didn't know.
All right. You certainly can get some legal advice as to what your next options are, but as of right now, I'll come back for an order, and that would be on the 9th, looks like,
Yes.
9th of April. And I suggest you get some legal advice, sir. I
And
can't
I'll
give
send
you
that
any.
order to you, the proposed order to you, sir.
All right, thank you.
23-3-103-08. I saw, this looks like it's on an order to show cause, but I don't show any service to that. Is Mr. Roberts? You want to come up to the table there, sir? I know we've got a number of things set, but I don't. Did you serve that order to show cause on anybody?
Yeah, I believe so. My wife did, I believe.
No, I don't.
Miss Baldwin, I believe, or the court. We haven't received anything back from them.
Did you?
When you're ready, Your Honor.
Yeah, go ahead. I've got a lot of stuff pending on this case, I know, but this was the order to show cause from March 6th, I think.
We haven't been served anything. So in this case, Willie noticed we happened to cruise through the docket and see that this case was on, looked it up in Odyssey, and surprise, surprise, found a number of things were on over the next couple of weeks that none of which we've been served with. So in this case, we just simply haven't been served. CR60s require a specific kind of service. That certainly hasn't happened. We're just asking the court to strike and award fees. In this case, I'd asked for a half an hour of fees. I was here for other cases, but also here for this. Half hour is about $260 of my time.
What I'm looking at in the court file, just from our record, I show an affidavit of service on March 20th, a couple days ago. A notice of hearing for April 2nd, and then I'm not sure what all those are, a number of different things. So I don't have any proof that this was ever served on your office for this hearing.
This hearing was for the, when I didn't show up to court. Supposedly, I was here though, Your Honor. I just couldn't get on Zoom on my. But I was in this courtroom on the young lady here. We talked.
Okay, well, here's the problem.
Yeah.
You put it on for an order to show cause, but you have to serve Ms. Baldwin that order.
I believe that she's been served.
But I don't have any proof of that.
Okay, on which order are we talking about?
The one that set today's hearing.
Today's hearing was for the,
This has to do with vacate the 11-9 order, which I think is the.
That's the bench order that was when he failed to show for
Yeah.
the MSC.
Right. Right, that's what that's about.
Oh, I didn't know there was, I just thought I had to come to court today and talk to you over this matter, because
But no, it's a hearing, so you'd have to serve her,
okay.
and then she can respond to it, and then we can make an order.
Okay,
So you can certainly note it on for another hearing down the line, but I can't address it today.
okay.
As I think I'm gonna reserve on fees. That certainly can be raised. I know we've got a number of hearings coming up, and I'll deal with those all together. So if you want to remind when that comes forward, I'll address that.
Very good.
Okay, so I'm not gonna issue an order. If you want to bring it back on, serve Ms. Baldwin timely, and we'll be.
Oh, okay, I didn't understand. I thought this was done
Okay.
through the court that I
Well,
talked to you today.
That's a court record that came out of a hearing, so it has to
Okay.
do with the other side. So anything you come to court, talk about the judge about, we need to have notice to the other side.
Okay.
So.
Sorry, Ms. Baldwin, I didn't know.
Okay, well, what I'm gonna suggest there too, before you file a lot of documents, make sure you get some legal advice, because you can get yourself into
I'm
trouble.
trying my best.
Okay, well, if you come to the courthouse, I believe every Monday, there are some lawyers out here you can chat with. They don't cost anything. They give you some direction. That may help keep you.
Well, I tried to talk to the, over there by the 14th,
Mhm.
but my previous Mr. Roush has talked to every one of
Okay,
them.
but if you come in, like I said, they're here and they're available for questions.
Okay,
Okay,
I
all
appreciate that.
right, so strike today and I'll reserve on fees. Okay.
So on numbers 1 and 2, Your Honor, that's Roush and Roberts 23-300-10308. I'd ask Your Honor just strike these. They weren't served. I don't see Mr. Roberts present.
Roberts is present. He is present here.
Okay, very
Come up to the counter there, sir. So let me see here. So you did not receive any of these documents?
We did not. And we actually filed a declaration of essentially non-service. The declaration or proof of mailing or hand delivery that was is just a notice of hearing. And then this is what they filed. We dispute it, that it was actually served on us. Interestingly, they note that it was served at 3:54, and you'll note that the other 2 prior affidavits of service in this case that Mr. has filed were at that time. We agree that we received the prior, but I think what they did was just copy essentially a proof of service and say, hey, it's the same, almost like it's a document to go forward, but not what its intended purpose is that you actually have to do the underlying action prior to signing it. And so in this case, we never received these documents. We only found them in the court file and became aware of them. Same position that we had last week in this case.
Sure.
Your Honor, she was served on Friday at like 2:30. I had my friend, I picked him up and he served her papers. And I got the court thing out here saying it was served to her on that day, stamped, which is Friday.
That would have been this last Friday?
Yes.
So that
For
would
the hearing, I was letting her know about the hearing today, because the last time I was here is because I didn't know about the hearing. He told me I need to put in for every hearing or whatever motion. I have to give it to her to let her know about court. So I turned it into her on last Friday. And her office is closed early, so I got there at like 2:30.
Well,
I can clarify when you're ready, Your Honor.
Well, give me just, I'm looking at 2 different affidavits of service, and if I went from 3:20, it talks about 3:11 at 3:54
That's
PM.
what I thought we were here for today.
Sure, just a second, please, till I
Sorry.
Okay. This has to do with removing an improper form. Which I guess whether they were served or not, it sounds like there's a disagreement on that. That wouldn't be sufficient service time. Anyway, Friday wouldn't be sufficient for sure.
I think this is regarding the one on the 20th. I served her another one on the Friday for another one, but I'm trying to look here. I'm looking into getting an attorney. I'm supposed to meet with her today, I hope. So,
Well, assuming that the one of the 20th was served, I'm just looking at that. This is the one that, at least in my court file, date it was filed here 3/20. It says service was done on 3/11 for a. Let's see what that's for. That's for removing a document. Did you get that one, Ms. Baldwin?
No, so that's what we were not served. I acknowledge that this last Friday, at about 2:30, he did drop off a motion for reconsideration. So I have received that as of Friday, but that's the only thing that we've actually received for quite some time, prior to really your order of dismissal. And then he blanket filed a whole bunch of motions immediately after that. Of those, what we've actually received is just what we received on Friday.
Well, the declaration of service I have for Friday says it was for a notice of hearing with no date on it. That's still, and that's what the affidavit of service says. I don't know what, so I don't know what was served on Friday.
Right. This last Friday, March 29th, was just the motion for order for reconsideration of dismissal order.
yeah,
And it has some attachments to it. And then it attaches motions. So it's a little odd because I'm not really sure what he's intending to do, because it's all kind of clumped together and attached together. So I'm not sure if he's using them he's using motions as exhibits. So it's served as this last Friday in the sense that it's the motion for reconsideration, but they're attached as exhibits to that motion for reconsideration. So it's a little odd, but in any event, it was received Friday, the 29th.
I didn't know there was any time limit here.
Well, there are contested motions, or I believe it's 21 days without looking that up. It certainly would, I mean, Friday would not be good service under any condition for any kind of case without an order shortening time. But what I guess my concern is, I'm looking at that, the one affidavit of service that was dated 3/20 talks about for today's hearing, us to remove a form from the record and then require opposing counsel to produce some allegations.
Yeah,
Well, just a second. I don't need an argument. That's what it says was served, and I have a motion for reconsideration that was filed here that same day. Okay. Well, yeah. I've got a declaration from your office, Ms. Baldwin, indicating that the number of documents filed on the 11th, another document filed, this is coming from Odyssey, it looks like. I'm just looking at your assistant's declaration that they're not all served at 354 based on the ones that I have.
So the his proofs of service are what they all say 354.
No,
So
well,
if you-
one says 235.
Oh, that's the most recent one. So that
Yeah.
I never had it when she, as of the date of that declaration, that hadn't
Mhm.
happened. So that's just,
Okay.
don't yet have a crystal ball yet. So all of the prior proofs of service, including the one from the 320, all say 354. So we acknowledged the first two proofs of service, which occurred back in February on the same date. I think they were filed different dates, but the actual service happened back in February. We acknowledge we received those documents. The proof of service that happened that's filed March 20th, that's what I believe is fraudulent because A, we don't have that. We were never served. And B, that's the one that says 354 that essentially matches the two prior proofs of service. So that's where I'm saying I think that they just looked at the prior proof of service and just essentially matched it as if it was almost like a docket notice and said, well, this is a document that has to be completed, but without acknowledging there's actions that have to go along with that. So I'll find another.
Okay. Well, I guess a couple of things. First off, I guess I'm concerned about the service issue on one hand, and the timeliness of service obviously would be insufficient for today. The motion for reconsideration is something we do off of, that's just done based on the pleadings, but that, so that would, I don't know if that was noted on for today.
I think today was supposed to be about, what Miss Chelsea said about the, I can't remember right now. You guys got me confused. No. I thought today was for the, well, there's just a couple orders that I wanted to talk about on this that was not in her, I have not received her discovery yet. And that was one of those I dropped off that she never got served. I have not received it back. And I think that was on the March, whatever, when it was served to Chelsea Baldwin's office. That's what that was. And I still haven't received discovery on that. And she's trying to dismiss this on it. Took a year, but you know, I haven't even received that. I haven't. Miss Baldwin had 3 vacations during this, which I don't know if I pushed it out or not. The financial statement she gave is totally wrong. Her assets is wrong. There's property not even put on it.
Well, sir, here's where we're at in this case. Looking back, I mean, this is a case that it was dismissed, if I recall correctly.
Yes, we're on for next week for presentation. We set presentation out a little ways, but
Why?
to give Mr. additional time, frankly.
And from what I've read in the bylaws, I wasn't over a year, Your Honor. I still had 3 days because we're in the middle of discovery when it was dismissed, I thought.
Well, okay.
I'm
Well,
you guys talk and I can't understand you guys.
Okay,
Sorry.
here's the thing, sir. We had a hearing, I issued an order. I haven't signed that order yet. That's going to be done April 9th. You have 10 days after that to file a motion to reconsider of that order.
That's what I did, I thought, Ron.
Well, I haven't entered that order yet.
Oh, okay, okay.
So that's premature. And then that motion would need to be served on Ms. Baldwin. She has a chance to respond to it.
Okay.
Then I make a decision on that. The rest of these, I'm not even sure that I have any ability to grant these, but I'm more concerned that if they haven't been properly served. So here's what I'm going to do on this one. I'm going to have you, all the things that you have filed with, including well, you may want to wait on the motion to reconsider till we actually do the order on the 9th. Get those over to Ms. Baldwin's office, and then I'll take a look at all those on the 9th when we're here.
Okay. I think I have them all on me right now. I don't know.
Okay. Is your office open, Ms. Baldwin, I assume?
Yes, we'll be open till 4.
Okay, so why don't you head over there with everything you got? They can make a copy of everything. I'll be happy to look at everything. We'll come back on the 9th and take a look at it.
Okay. Well, Ms. Baldwin, I'm not sure if I have the exact one. But I did file all these with the courts.
Well, anything you file here has to be filed on them, so they have an opportunity.
I know, I'm catching on how,
Okay.
that's why the motions of the orders I filed with her. I can't even bring the people in to drop them off at her
Okay.
office if that's need
Well,
be.
that-
Cause she was served on proper time. Maybe not Friday, but we had court on Tuesday. I did it on Friday, so.
Well, Friday is not enough time for a hearing on Tuesday.
Okay.
Because normally for a contested hearing, which these would all be contested hearing, is 21 days. So it's like 3 weeks.
I'm trying.
Okay,
And hopefully I get it, talk to an attorney today.
okay. Hopefully that'll help, and then we can hopefully move
But
this
Ms.
forward.
Baldwin, if I don't get it into you today, I'll have them tomorrow for you.
Okay.
Okay.
Come back on the 9th and take a look at presentation as well as anything else that looks like it's ready to go.
Okay. Thank you.
Okay. And I just asked the court to reserve fees. That's what we did last week as well.
I will take all that up when we have a hearing with everything ready to go. And
Very
we'll reserve on that, so,
Thank you. Over to next week.
okay.
Judge Basher, Ms. Joslyn on number 7 is in your waiting room. Would you mind admitting her, please?
I'd be happy to
Thank
not see anybody in my waiting room. She is in the, oh, wait a minute, maybe she is.
She emailed me and indicated that she
That's
was.
strange. Looks like we had several people that got in there.
Thank you.
Let me see, I've got John Roberts and Leonard Bouch. He is present. Can I have you step up to the table by a microphone there, sir, so that and Miss Baldwin, do we have you here? I mean, I lost my screen.
Yes, sir.
For some reason, my Zoom disappeared. Give me just a second. It's very strange.
Can the court hear me or neither?
I can hear you. I lost my video of Zoom for some reason. Very strange. Give me 1 second here. There we go. Okay, got their screen back. I don't know what happened there, but so I have Mr. Roberts as president of
Yes.
court. And we are here for a number of items.
Yes. So first, let's take up the presentation.
Let me get to that here. Where did that go? I'm having technical issues today and I apologize. Okay. Let me see here. So I did receive, I've got a bench copy of a proposed as well as an order, and this was the order from March 12th. And so, Mr. Roberts, I understand you're asking to have this reconsidered. I understand that. That's a
Yes,
separate issue. Do you have any objection that this order says what I did order?
For which,
This is the order of dismissal.
oh, yes, I disagree on the order of dismissal because I have proof that Ms. Baldwin's been given all the paperwork.
Okay, that's a
And it
different
can-
question.
Okay.
My question is, does this piece of paper say what I said when I dismissed the case?
Yes, Your Honor.
Okay, so we'll start there. And I recognize you did file a motion to reconsider
We can take that up next once you're ready.
in just a second. So I'm going to enter this. Okay, so that's down. All right, so let me see here. All right, so to sign that order. Oh, so who's that? And then if I go, I know I'm having difficulty with my computer today, but I apologize for that. So,
Sometimes they're slow.
all right, so I had a motion filed. This was filed 3/11 to remove an improper form. And on the same date, a motion to require opposing counsel to produce evidence of substantiating allegations. And counsel, did you receive those two motions?
I did not. So as noted, we filed 2 declarations. The first noting that we didn't receive them the first time. The court, either last week or the week before, I think it was last week, when we were before the court, you said, no, you have to serve them. Said, do it by close of the day. We waited. I directed my staff to, wait until, the clock strikes 4 and, don't close a second earlier. They actually waited after. He did not serve those on my office, didn't serve them the next day. We filed an additional declaration that just verifies we did not serve those documents. So as we sit today, those motions still have never been served. We were served with the motion for reconsideration. We were not served with these other motions.
Okay. Mr. Roberts?
I have the paperwork showing that she was served by the people. I even got pictures on one and when she was standing in front of Miss Baldwin's office to serve her these papers that I put in.
Did you file those already?
Yes, they've been filed. These are copies of the court, but these are statements from the people that delivered them. And
Is that since we were here last?
yeah.
Okay, because
Miss Baldwin said that she hasn't received any of this paperwork and I've got proof that she was served. These are statements today that I had to go. That's why I was almost late today, trying to find that, get them. So I have some for Miss Baldwin. She was in here to give to her. I have copies of everything that was delivered to her office.
When was that done?
Let's see. My friend Kevin delivered, it was 4/8. He delivered it it was on office call 3/29. The other one was Andy Bolden, and that was February 29th at 3:42. And the other one was Gary, and my wife brought him down from Winlock and he delivered him on 3/11. Oh, excuse me, 3/20. I believe that's what I have here.
So let me ask you that when we were here
Yeah.
last week, correct?
Yeah.
And I indicated you needed to serve these on her office. So that would have been after April 2nd.
Okay, well, I misunderstood because she's already been served them. I got proof that she's been served them.
Okay. Well, I was real clear that you needed to serve those.
Okay, I thought I already had served them, Your Honor. I misunderstood you then.
Okay.
I thought you wanted me to prove that I thought if I brought proof that she was served, that would be enough.
Well, when we were here last week.
Yes.
So if you want me to look at those motions, I'm happy to do that, but she needs to, and she's saying she didn't get them. She's got her staff has provided declarations that they were not received since we were here last week, and then they were received prior to that. So I'm not able to go ahead on those motions.
Okay. So should I drop what I have at her office today? I have copies of
Well,
everything.
you could serve her.
Okay. Well, I can't serve her, so.
You can't, somebody else needs to serve her
Okay.
and then provide documentation that that's been done. And then we can have a hearing. But
Okay.
I can't do a hearing.
I'm sorry, Your Honor, I misunderstood.
Oh, that's okay. I understand.
But I will drop
but-
them off
And
today.
here's the problem, okay, is every time we keep coming back to court, they're sitting there not doing other stuff and we're here for court and you're here for court. I understand that, but there's a process of things, how they happen.
Okay,
Okay.
I had people serve her, I had statements that they served her, I had the court, that I misunderstand because I thought the court stamped it. I came over here after they were served and had them put into the court. And
Right, and I have those. I think I saw those. There's one from 329.
should be three different ones, I think, Your Honor, whichever one she's saying she hasn't gotten. And I have a copy of it right now, and I will have one of these people serve her right up front of her. I figured I just got papers served by her today. I don't even know what they're about.
I don't know what that is. So,
Yeah, I haven't even looked at it.
okay, so those two motions, we're not going to move forward. I'm going to have somebody serve them, get somebody to sign a document they got them
Okay.
at her office. So,
Okay.
so we don't have a question anymore.
May I ask a question?
Yes.
Which documents exactly has she not gotten? Which motions or orders has she not gotten?
I'm going to assume, other than the motion to reconsider, nothing. So everything that you want me to consider,
Okay.
take them to her office, serve them, and we're going to need another hearing date. And every time we keep doing this, it's going to keep
Well,
costing more
I'm
money.
just saying, I mean, I got a picture of, she took a picture of her cell phone with her card on it, Miss Baldwin's card, and that's when she served her.
Okay. Okay, well, I have a declaration that says it didn't happen, so I got two parties and I don't have them here that I can really
Okay.
have some kind of a hearing about that. So you'll need to reserve this.
Okay.
And my staff will always like sign on the pleading itself. So if before he files it, if he wants to bring it, we can stamp it and note that we received it so that there's no question, and that's sort of can operate as a proof of service before it gets filed. We're happy to do that.
Okay, I'm sorry, Miss Baldwin. I thought you had been served. I really did.
So here's what I'll have you do, sir. Okay, just want you to listen. Take the documents you want her to get, take a new version of that over to her office. They can sign and leave them a copy, and then file the one they signed. Then I'll know they got them.
Okay.
And then we'll be able to come back and have a hearing.
Okay.
You'll need to set another date on this. And I can tell you right now, we do not have court on the 30th. So it'd have to be one of the other Tuesdays. Because we don't have court on the 30th.
Okay, whichever Miss Baldwin can do that.
Well, you'll need to figure out a date, and then she needs enough time to respond to the motions. Okay?
Okay.
And then
So
the
that-
consider it separate. So, Ms. Baldwin?
So that only leaves the motion for reconsideration. Since the order has now been entered, that motion is right. I just asked the court to give me a week. I already have the response drafted. I just going to clean it up and get it filed to your honor.
That's fine. I think we put it at 10 days at least from our last hearing. So if that's going to be done within the week, then we'll and these are things they're done outside of court anyway. So given all the things that are on my desk right now, I'm unlikely to get to it for a week anyway.
Fair enough.
Okay. I think that's all the motions. So you're going to need to reserve those, get them renoted. I'll look at your motion to reconsider once I have a response to it, and I'll be happy to get a ruling on that.
Okay.
Okay. All right. And sir, I'm going to suggest if you come here on a Monday from 12 to 2, there are some lawyers in the lobby. They can give you some guidance.
I've been trying. It's hard to get down there all the time.
Well, I'm just saying that's the best way for you to get some free legal advice.
Okay.
And I'm not allowed to give it to you. I've given you
I
probably as much as I can. All right.
Okay.
All right. So strike all of those hearings today, and then I'll wait for a response on the motion to reconsider. Okay. And I'll reserve on all fee requests that were still out there. All right, then the last matter I have on the docket today is the Diaz and Hawkins matter, which is 48108.
And that matter is ready, Your Honor.
I got